HAPTER the Union I, TE Executive the President and Vice President 52. The President of India. There shall be a President of India. 53. Executive power of the Union. 1. The executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. 2. Without prejudice to the generality of the foregoing provision, the supreme command of the defense forces of the Union shall be vested in the President and the exercise thereof shall be regulated by law. 3. Nothing in this article shall a. Be deemed to transfer to the President any functions conferred by any existing law on the government of any state or other authority, or b. Prevent Parliament from conferring by law functions on authorities other than the President. 54. Election of President. The President shall be elected by the members of an electoral college consisting of a. The elected members of both Houses of Parliament, and b. The elected members of the legislative assemblies of the states. 1. Explanation. In this article and in Article 55, state includes the National Capital Territory of Delhi and the Union Territory of Puducherry. 55. Manner of election of President. 1. As far as practicable, there shall be uniformity in the scale of representation of the different states at the election of the President. 2. For the purpose of securing such uniformity among the states inter se as well as parity between the states as a whole and the Union, the number of votes which each elected member of Parliament and of the Legislative Assembly of each state is entitled to cast at such election shall be determined in the following manner. A. Every elected member of the Legislative Assembly of a state shall have as many votes as there are multiples of 1,000 in the quotient obtained by dividing the population of the state by the total number of the elected members of the Assembly, blank, underscore, blank, 1. Ins. By the Constitution 70th Amendment Act, 1992, S. 2 W. E. F. The 6th of January 1995. Now Puducherry v. the Pondicherry Alteration of Name Act, 2006 44 of 2006 S. 3 W. E. F. The 10th of January 2006. 26. 27. The Constitution of India Part 5. The Union be if, after taking the said multiples of 1,000, the remainder is not less than 500, then the vote of each member referred to in subclause A shall be further increased by 1. C. Each elected member of either House of Parliament shall have such number of votes as may be obtained by dividing the total number of votes assigned to the members of the legislative assemblies of the states under subclauses A and B by the total number of the elected members of both Houses of Parliament, fractions exceeding 1/2 being counted as 1 and other fractions being disregarded. 3. The election of the President shall be held in accordance with the system of proportional representation by means of the single transferable vote and the voting at such election shall be by secret ballot. 1. Explanation. In this article, the expression, population, means the population is ascertained at the last preceding census of which the relevant figures have been published, provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2 published, be construed as a reference to the 1971 census. 2026 have been 56. Term of office of President. 1. The President shall hold office for a term of 5 years from the date on which he enters upon his office, provided that a. The President may, by writing under his hand addressed to the Vice President, resign his office. B. The President may, for violation of the Constitution, be removed from office by impeachment in the manner provided in Article 61. C. The President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. 2. Any resignation addressed to the Vice President under Clause A of the proviso to Clause 1 shall forthwith be communicated by him to the Speaker of the House of the People. Blank, underscore, blank, 1. Subs. By the Constitution 42nd Amendment Act, 1976, S. 12, for the explanation W. E. F. The 1st of March 1977. 2. Subs. By the Constitution 84th Amendment Act, 2001, S. 2, for 2000, W. E. F. The 21st of February 2002. 28. The Constitution of India Part 5, the Union 57. Eligibility for re-election. A person who holds, or who has held, office as President shall, subject to the other provisions of this Constitution, be eligible for re-election to that office. 58. Qualifications for election as President. 1. No person shall be eligible for election as President unless he a. Is a citizen of India, b. Has completed the age of 35 years, and c. Is qualified for election as a member of the House of the People. 2. A person shall not be eligible for election as president if he holds any office of profit under the Government of India or the government of any state or under any local or other authority subject to the control of any of the said governments. Explanation. For the purposes of this article, a person shall not be deemed to hold any office of profit by reason only that he is the president or vice president of the union or the governor one either for the union or for any state. Of any state or as a minister. 59. Conditions of President's office. 1. The President shall not be a member of either House of Parliament or of a House of the Legislature of any state, and if a member of either House of Parliament or of a House of the Legislature of any state be elected President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as President. 2. The President shall not hold any other office of profit. 3. The President shall be entitled without payment of rent to the use of his official residences and shall be also entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and, until provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. 4. The emoluments and allowances of the President shall not be diminished during his term of office. 60. Oath or affirmation by the President. Every president and every person acting as president or discharging the functions of the president shall, before entering upon his office, make and subscribe in the presence of the Chief Justice of India or, in his absence, the senior-most judge of the Supreme Court available, an oath or affirmation in the following form, that is to say, blank, underscore, blank, 1. The words, Raj Pramukh or Uparaj Pramukh, omitted by the Constitution, 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956. 29. The Constitution of India, Part 5. The Union I, A.B., do swear in the name of God that I will faithfully execute the office. Solemnly affirm of President, or discharge the functions of the President of India and will to the best of my ability preserve, protect and defend the Constitution and the law and that I will devote myself to the service and well-being of the people of India. 61. Procedure for impeachment of the President. 1. When a president is to be impeached for violation of the Constitution, the charge shall be preferred by either House of Parliament. 2. No such charge shall be preferred unless, a. The proposal to prefer such charge is contained in a resolution which has been moved after at least 14 days' notice in writing signed by not less than 1/4 of the total number of members of the House has been given of their intention to move the resolution, and b. Such resolution has been passed by a majority of not less than 2/3 of the total membership of the House. 3. When a charge has been so preferred by either House of Parliament, the other House shall investigate the charge or cause the charge to be investigated and the President shall have the right to appear and to be represented at such investigation. 4. If as a result of the investigation a resolution is passed by a majority of not less than 2/3 of the total membership of the House by which the charge was investigated or caused to be investigated, declaring that the charge preferred against the President has been sustained, such resolution shall have the effect of removing the President from his office as from the date on which the resolution is so passed. 62. Time of holding election to fill vacancy in the office of President and the term of office of person elected to fill casual vacancy. 1. An election to fill a vacancy caused by the expiration of the term of office of President shall be completed before the expiration of the term. 2. An election to fill a vacancy in the office of President occurring by reason of his death, resignation or removal, or otherwise shall be held as soon as possible after, and in no case later than 6 months from, the date of occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 56, be entitled to hold office for the full term of 5 years from the date on which he enters upon his office. 63. The Vice President of India. There shall be a Vice President of India. 64. The Vice President to be ex officio Chairman of the Council of States. The Vice President shall be ex officio Chairman of the Council of the States and shall not hold any other office of profit. 30. The Constitution of India, Part 5. The Union provided that during any period when the Vice President acts as President or discharges the functions of the President under Article 65, he shall not perform the duties of the office of Chairman of the Council of States and shall not be entitled to any salary or allowance payable to the Chairman of the Council of States under Article 97. 65. The Vice President to act as President or to discharge his functions during casual vacancies in the office, or during the absence, of President. 1. In the event of the occurrence of any vacancy in the office of the President by reason of his death, resignation or removal, or otherwise, the Vice President shall act as President until the date on which a new President elected in accordance with the provisions of this chapter to fill such vacancy enters upon his office. 2. When the President is unable to discharge his functions owing to absence, illness or any other cause, the Vice President shall discharge his functions until the date on which the President resumes his duties. 3. The Vice President shall, during, and in respect of, the period while he is so acting as, or discharging the functions of, President, have all the powers and immunities of the President and be entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and, until provision in that behalf is so made, such emoluments, allowances and privileges as are specified in the second schedule. 166. Election of Vice President. 1. The Vice President shall be elected by the members of an electoral college consisting of the members of both Houses of Parliament, in accordance with the system of proportional representation by means of the single transferable vote, and the voting at such election shall be by secret ballot. 2. The Vice President shall not be a member of either House of Parliament or of a House of the Legislature of any state, and if a member of either House of Parliament or of a House of the Legislature of any state be elected Vice President, he shall be deemed to have vacated his seat in that House on the date on which he enters upon his office as Vice President. 3. No person shall be eligible for election as Vice President unless he, a. is a citizen of India, b. has completed the age of 35 years, and, blank, underscore, blank, 1. Subs. By the Constitution 11th Amendment Act, 1961, s. 2. For members of both Houses of Parliament assembled at a joint meeting, W. E. F. The 19th of December 1961. 31. The Constitution of India Part 5, the Union C. is qualified for election as a member of the Council of States. 4. A person shall not be eligible for election as Vice President if he holds any office of profit under the Government of India or the Government of any state or under any local or other authority subject to the control of any of the said governments. Explanation. For the purposes of this article, a person shall not be deemed to hold any office of profit by reason only that he is the President or Vice President of the Union or the Governor one either for the Union or for any state, of any state or as a minister. 67. Term of office of Vice President. The Vice President shall hold office for a term of 5 years from the date on which he enters upon his office, provided that, a Vice President may, by writing under his hand addressed to the President, resign his office. b. A Vice President may be removed from his office by a resolution of the Council of States passed by a majority of all the then members of the Council and agreed to by the House of the People, but no resolution for the purpose of this clause shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. c. A Vice President shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. 68. Time of holding election to fill vacancy in the office of Vice President and the term of office of person elected to fill casual vacancy. 1. An election to fill a vacancy caused by the expiration of the term of office of Vice President shall be completed before the expiration of the term. 2. An election to fill a vacancy in the office of Vice President occurring by reason of his death, resignation or removal, or otherwise shall be held as soon as possible after the occurrence of the vacancy, and the person elected to fill the vacancy shall, subject to the provisions of Article 67, be entitled to hold office for the full term of 5 years from the date on which he enters upon his office. 69. Oath or affirmation by the Vice President. Every Vice President shall, before entering upon his office, make and subscribe before the, blank, underscore, blank, 1. The words, Raj Pramukh or Uparaj Pramukh, omitted by the Constitution 7th Amendment Act, 1956, s. 29 and SCH. W. E. F. The 11th of January 1956. 32. The Constitution of India Part 5, the Union President, or some person appointed in that behalf by him, an oath or affirmation in the following form, that is to say, I, A.B., do swear in the name of God that I will bear true faith and solemnly affirm allegiance to the Constitution of India as by law established and that I will faithfully discharge the duty upon which I am about to enter. 70. Discharge of President's functions in other contingencies. Parliament may make such provision as it thinks fit for the discharge of the functions of the President in any contingency not provided for in this chapter. 171. Matters relating to, or connected with, the election of a President or Vice President. 1. All doubts and disputes arising out of or in connection with the election of a President or Vice President shall be inquired into and decided by the Supreme Court, whose decision shall be final. 2. If the election of a person as President or Vice President is declared void by the Supreme Court, acts done by him in the exercise and performance of the powers and duties of the office of President or Vice President, as the case may be, on or before the date of the decision of the Supreme Court shall not be invalidated by reason of that declaration. 3. Subject to the provisions of this Constitution, Parliament may by law regulate any matter relating to or connected with the election of a president or vice president. 4. The election of a person as president or vice president shall not be called in question on the ground of the existence of any vacancy for whatever reason among the members of the Electoral College electing him. 72. Power of President to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. 1. The President shall have the power to grant pardons, reprieves, respites or remissions of punishment or to suspend, remit or commute the sentence of any person convicted of any offense. A. In all cases where the punishment or sentences by a court-martial, ___1. Subs. By the Constitution 39th Amendment Act, 1975, S. 2 W. E. F. the 8th of October 1975, and further subs. By the Constitution 44th Amendment Act, 1978, S. 10. W. E. F. the 20th of June 1979. 33. The Constitution of India Part 5, the Union B. In all cases where the punishment or sentence is for an offence against any law relating to a matter to which the executive power of the Union extends, c. In all cases where the sentence is a sentence of death. 2. Nothing in subclause A of Clause 1 shall affect the power conferred by law on any officer of the armed forces of the Union to suspend, remit or commute a sentence passed by a court-martial. 3. Nothing in subclause C of Clause 1 shall affect the power to suspend, remit or commute a sentence of death exercisable by the governor of a state under any law for the time being in force. 1****73. Extent of executive power of the Union. 1. Subject to the provisions of this Constitution, the executive power of the Union shall extend, a. to the matters with respect to which Parliament has power to make laws, and b. to the exercise of such rights, authority and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement, provided that the executive power referred to in subclause A shall not, save as expressly provided in this Constitution or in any law made by Parliament, extend in any state to **** to matters with respect to which the legislature of the state has also power to make laws. 2. Until otherwise provided by Parliament, a state and any officer or authority of a state may, notwithstanding anything in this article, continue to exercise in matters with respect to which Parliament has power to make laws for that state such executive power or functions as the state or officer or authority thereof could exercise immediately before the commencement of this Constitution. *__1. The words, Raj Pramukh, omitted by the Constitution 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956. 2. The words and letters, specified in Part A or Part B of the first schedule, omitted by the Constitution 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956. 34. The Constitution of India Part 5, the Union Council of Ministers 174. Council of Ministers to aid and advise President. Be a Council of Ministers with the Prime Minister at the head to aid and advise the President who shall, in the exercise of his functions, act in accordance with such advice. 1. There shall 2. Provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. 2. The question whether any, and if so what, advice was tendered by ministers to the President shall not be inquired into in any court. 75. Other provisions as to ministers. 1. The Prime Minister shall be appointed by the President and the other ministers shall be appointed by the President on the advice of the Prime Minister. 3. 1a. The total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members of the House of the People. 1b. A member of either House of Parliament belonging to any political party who is disqualified for being a member of that House under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as a minister under clause 1 for duration of the period commencing from the date of his disqualification till the date on which the term of his office as such member would expire or where he contests any election to either House of Parliament before the expiry of such period, till the date on which he is declared elected, whichever is earlier. 2. The ministers shall hold office during the pleasure of the President. 3. The Council of Ministers shall be collectively responsible to the House of the People. 4. Before a minister enters upon his office, the President shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the third schedule. *__1. Subs. by the Constitution 42nd Amendment Act, 1976, S.13, for cl. 1 w. e. f. The 1st of March 1977. 2. Ins. by the Constitution 44th Amendment Act, 1978, S. 11 w. e. f. The 20th of June 1979. 3. Ins. by the Constitution 91st Amendment Act, 2003, S. 2 w. e. f. The 1st of January 2004. 35. The Constitution of India Part 5, the Union 5. A minister who for any period of 6 consecutive months is not a member of either House of Parliament shall at the expiration of that period cease to be a minister. 6. The salaries and allowances of ministers shall be such as Parliament may from time to time by law determine and, until Parliament so determines, shall be as specified in the second schedule. The Attorney General for India 76. Attorney General for India. 1. The President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General for India. 2. It shall be the duty of the Attorney General to give advice to the Government of India upon such legal matters, and to perform such other duties of a legal character, as may from time to time be referred or assigned to him by the President, and to discharge the functions conferred on him by or under this Constitution or any other law for the time being in force. 3. In the performance of his duties the Attorney General shall have right of audience in all courts in the territory of India. 4. The Attorney General shall hold office during the pleasure of the President, and shall receive such remuneration as the President may determine. Conduct of Government Business 77. Conduct of Business of the Government of India. 1. All executive action of the Government of India shall be expressed to be taken in the name of the President. 2. Orders and other instruments made and executed in the name of the President shall be authenticated in such manner as may be specified in Rules 1 to be made by the President, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. 3. The President shall make rules for the more convenient transaction of the business of the Government of India, and for the allocation among ministers of the said business. 2. 4 blank, underscore, blank, 1. See not if and no. SO 2297, dated 3 November 1958, Gazette of India, Extraordinary, Part 2, Sec. 3e page 1315, as amended from time to time. 2. Cl. 4 was ins. by the Constitution 42nd Amendment Act, 1976, S.14 w. e. f. The 1st of March 1977 and omitted by the Constitution 44th Amendment Act, 1978, S. 12 w. e. f. The 20th of June 1979. 36. The Constitution of India Part 5, the Union 78. Duties of Prime Minister as respects the furnishing of information to the President, etc., it shall be the duty of the Prime Minister, a. To communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation, b. To furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, and c. If the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Chapter 2. Parliament General 79. Constitution of Parliament. There shall be a Parliament for the Union which shall consist of the President and 2 houses to be known respectively as the Council of States and the House of the People. 80. Composition of the Council of States. 1. States shall consist of 1 2 the Council of 12 members to be nominated by the President in accordance with the provisions of Clause 3 and 3b not more than 238 representatives of the states and of the Union territories. 2. The allocation of seats in the Council of States to be filled by representatives of the states 3 and of the Union territories shall be in accordance with the provisions in that behalf contained in the 4th schedule. 3. The members to be nominated by the President under sub-clause A of Clause 1 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely, literature, science, art and social service. Blank, underscore, blank, 1. Subs. By the Constitution 35th Amendment Act, 1974, S. 3, for, the Council of States, W. E. F. The 3rd of January 1975. 2. The words, subject to the provisions of para. 4 of the 10th schedule, omitted by the Constitution 36th Amendment Act, 1975, S. 5 W. E. F. the 26th of April 1975. 3. Added by the Constitution, 7th Amendment Act, 1956, S. 3 W. E. F. the 11th of January 1956. 37. The Constitution of India, Part 5, the Union. 4. The representatives of each state 1 ***** in the Council of States shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. 5. The representatives of the 2 Union territories in the Council of States shall be chosen in such manner as Parliament may by law prescribe. 381. Composition of the House of the People. 1. Provisions of Article 3315-64 subject to the *****, the House of the People shall consist of a. Not more than 530 members chosen by direct election from territorial constituencies in the states, and b. Not more than 720 members to represent the Union territories chosen in such manner as Parliament may by law provide. 2. For the purposes of sub-clause a of Clause 1. 8. There shall be allotted to each state a number of seats in the House of the People in such manner that the ratio between that number and the population of the state is, so far as practicable, the same for all states, and b. Each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it is, so far as practicable, the same throughout the state. 8. Provided that the provisions of subclause a of this clause shall not be applicable for the purpose of allotment of seats in the House of the People to any state so long as the population of that state does not exceed 6 millions. *_*1. The words and letters, specified in Part A or Part B of the first schedule, omitted by the Constitution 7th Amendment Act, 1956, S. 3 W. E. F. the 11th of January 1956. 2. Subs. By S. 3. Ibid. For states specified in Part C of First Schedule, W. E. F. the 11th of January 1956. 3. Subs. By S. 4. Ibid. For Arts, 81 and 82 W. E. F. the 11th of January 1956. 4. Subs. By the Constitution 35th Amendment Act, 1974, S. 4. For, subject to the provisions of Art. 331 inches W. E. F. the 3rd of January 1975. 5. The words and figure, and para. 4 of the 10th Schedule, omitted by the Constitution 36th Amendment Act, 1975, S. 5 W. E. F. the 26th of April 1975. 6. Subs. By the Goa, Damon and Due Reorganization Act, 1987 18 of 1987 S. 63, for 525 members, W. E. F. the 30th of May 1987. 7. Subs. By the Constitution 31st Amendment Act, 1973, S. 2, for 25 members, W. E. F. the 17th of October 1973. 8. Ins. By S. 2, Ibid. W. E. F. the 17th of October 1973. 38. The Constitution of India, Part 5, the Union. 3. In this article, the expression, population, means the population as ascertained at the last preceding census of which the relevant figures have been published. 1. Provided that the reference in this clause to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published. 3. Be construed, I, for the purposes of subclause A of Clause 2 and the proviso to that clause, as a reference to the 1971 census, and E, for the purposes of subclause B of Clause 2 as a reference to the 2001 census. 82. Readjustment after each census. Upon the completion of each census, the allocation of seats in the House of the People to the states and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine. Provided that such readjustment shall not affect representation in the House of the People until the dissolution of the then existing House. 5. Provided further that such readjustment shall take effect from such date as the President may, by order, specify, and until such readjustment takes effect, any election to the House may be held on the basis of the territorial constituencies existing before such readjustment. 6. Provided also that until the relevant figures for the first census taken after the year 2026 have been published, it shall not be necessary to 7. Readjust, *__1. Added be the Constitution 42nd Amendment Act, 1976, S. 15 W. E. F. The 1st of March 1977. 2. Subs. By the Constitution 84th Amendment Act, 2001, S. 3, for 2000, W. E. F. The 21st of February 2002. 3. Subs. By S.3, IBID, for certain words W. E. F. The 21st of February 2002. 4. Subs. By the Constitution 87th Amendment Act, 2003, S. 2, for 1991, W. E. F. The 22nd of June 2003. 5. Ins. By the Constitution 42nd Amendment Act, 1976, S. 16 W. E. F. The 1st of March 1977. 6. Subs. By the Constitution 84th Amendment Act, 2001, S. 4, for 2000, W. E. F. The 21st of February 2002. 7. Subs. By S.4, IBID, for certain words W. E. F. The 21st of February 2002. 39. Under this article, the Constitution of India Part 5, the Union I. The allocation of seats in the House of the People to the states is readjusted on the basis of the 1971 census, and E. The division of each state into territorial constituencies is may be readjusted on the basis of the 2001 census. 83. Duration of Houses of Parliament. 1. The Council of States shall not be subject to dissolution, but as nearly as possible 1/3 of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. 2. The House of the People, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and no longer and the expiration of the said period of 2. The House, 5 years, shall operate as a dissolution of, provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period not exceeding 1 year at a time and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. 84. Qualification for membership of Parliament. A person shall not be qualified to be chosen to fill a seat in Parliament unless he, 3a. Is a citizen of India, and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the 3rd Schedule. B. Is, in the case of a seat in the Council of States, not less than 30 years of age and, in the case of a seat in the House of the People, not less than 25 years of age, and C. Possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. Blank, underscore, blank. 1. Subs. By the Constitution 87th Amendment Act, 2003, S. 3, for 1991, W. E. F. The 22nd of June 2003. 2. Subs. By the Constitution 42nd Amendment Act, 1976, S. 17, for 5 years, W. E. F. The 1st of March 1977, and further subs. By the Constitution 44th Amendment Act, 1978, S. 13, for 6 years, W. E. F. The 20th of June 1979. 3. Subs. By the Constitution 16th Amendment Act, 1963, S. 3, for CL. 8 W. E. F. The 10th of May 1963. 40. The Constitution of India Part 5, the Union 185. Sessions of Parliament, Prorogation and Dissolution. 1. The President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. 2. The President may from time to time, A. Prorogue the Houses or either House, B. Dissolve the House of the People. 86. Right of President to address and send messages to Houses. 1. The President may address either House of Parliament or both Houses assembled together, and for that purpose require the attendance of members. 2. The President may send messages to either House of Parliament, whether with respect to a bill then pending in Parliament or otherwise, and a House to which any message is so sent shall with all convenient dispatch consider any matter required by the message to be taken into consideration. 2. 87. Special Address by the President. 1. At the commencement of the first session after each general election to the House of the People and at the commencement of the first session of each year, the President shall address both Houses of Parliament assembled together and inform Parliament of the causes of its summons. 3. Provision shall be made by the rules regulating the procedure of either House for the allotment of time for discussion of the matters referred to in such address. 88. Rights of Ministers and Attorney General as respects Houses. Every Minister and the Attorney General of India shall have the right to speak in, and otherwise to take part in the proceedings of, either House, any joint sitting of the Houses, and any committee of Parliament of which he may be named a member, but shall not by virtue of this article be entitled to vote. Blank, underscore, blank. 1. Subs. By the Constitution First Amendment Act, 1951, S. 6, for Art. 85 W. E. F. The 18th of June 1951. 2. Subs. By the Constitution First Amendment Act, 1951, S. 7, for every session, W. E. F. The 18th of June 1951. 3. The words, and for the precedence of such discussion over other business of the House, omitted by S. 7, Ibid. W. E. F. The 18th of June 1951. 41. The Constitution of India, Part 5, the Union Officers of Parliament 89. The Chairman and Deputy Chairman of the Council of States. 1. The Vice President of India shall be ex officio Chairman of the Council of States. 2. The Council of States shall, as soon as may be, choose a member of the Council to be Deputy Chairman thereof and, so often as the office of Deputy Chairman becomes vacant, the Council shall choose another member to be Deputy Chairman thereof. 90. Vacation and resignation of, and removal from, the office of Deputy Chairman. A member holding office as Deputy Chairman of the Council of States, A. shall vacate his office if he ceases to be a member of the Council, B. may at any time, by writing under his hand addressed to the Chairman, resign his office, and C. may be removed from his office by a resolution of the Council passed by a majority of all the then members of the Council. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. 91. Power of the Deputy Chairman or other person to perform the duties of the office of, or to act as, Chairman. 1. While the office of Chairman is vacant, or during any period when the Vice President is acting as, or discharging the functions of, President, the duties of the office shall be performed by the Deputy Chairman, or, if the office of Deputy Chairman is also vacant, by such member of the Council of States as the President may appoint for the purpose. 2. During the absence of the Chairman from any sitting of the Council of States the Deputy Chairman, or, if he is also absent, such person as may be determined by the rules of procedure of the Council, or, if no such person is present, such other person as may be determined by the Council, shall act as Chairman. 92. The Chairman or the Deputy Chairman not to preside while a resolution for his removal from office is under consideration. 1. At any sitting of the Council of States, while any resolution for the removal of the Vice President from his office is under consideration, the Chairman, or while any resolution for the removal of the Deputy Chairman from his office is under consideration, the Deputy Chairman, shall not, though he is present, preside, and the provisions of Clause 2 of Article 91 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Chairman, or, as the case may be, the Deputy Chairman, is absent. 42. The Constitution of India Part 5, the Union 2. The Chairman shall have the right to speak in, and otherwise to take part in the proceedings of, the Council of States while any resolution for the removal of the Vice President from his office is under consideration in the Council, but, notwithstanding anything in Article 100, shall not be entitled to vote at all on such resolution or on any other matter during such proceedings. 93. The Speaker and Deputy Speaker of the House of the People. The House of the People shall, as soon as may be, choose 2 members of the House to be respectively Speaker and Deputy Speaker thereof and, so often as the office of Speaker or Deputy Speaker becomes vacant, the House shall choose another member to be Speaker or Deputy Speaker, as the case may be. 94. Vacation and resignation of, and removal from, the offices of Speaker and Deputy Speaker. A member holding office as Speaker or Deputy Speaker of the House of the People. A. Shall vacate his office if he ceases to be a member of the House of the People. B. May at any time, by writing under his hand addressed, if such member is the Speaker, to the Deputy Speaker, and if such member is the Deputy Speaker, to the Speaker, resign his office, and C. may be removed from his office by a resolution of the House of the People passed by a majority of all the then members of the House. Provided that no resolution for the purpose of Clause C shall be moved unless at least 14 days' notice has been given of the intention to move the resolution. Provided further that, whenever the House of the People is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the House of the People after the dissolution. 95. Power of the Deputy Speaker or other person to perform the duties of the office of, or to act as, Speaker. 1. While the office of Speaker is vacant, the duties of the office shall be performed by the Deputy Speaker or, if the office of Deputy Speaker is also vacant, by such member of the House of the People as the President may appoint for the purpose. 2. During the absence of the Speaker from any sitting of the House of the People, the Deputy Speaker or, if he is also absent, such person as may be determined by the rules of procedure of the House, or, if no such person is present, such other person as may be determined by the House, shall act as Speaker. 43. The Constitution of India, Part 5, the Union, 96. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. 1. At any sitting of the House of the People, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker, shall not, though he is present, preside, and the provisions of Clause 2 of Article 95 shall apply in relation to every such sitting as they apply in relation to a sitting from which the Speaker, or, as the case may be, the Deputy Speaker, is absent. 2. The Speaker shall have the right to speak in, and otherwise to take part in the proceedings of, the House of the People while any resolution for his removal from office is under consideration in the House and shall, notwithstanding anything in Article 100, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings but not in the case of an equality of votes. 97. Salaries and allowances of the Chairman and Deputy Chairman and the Speaker and Deputy Speaker. There shall be paid to the Chairman and the Deputy Chairman of the Council of States, and to the Speaker and the Deputy Speaker of the House of the People, such salaries and allowances as may be respectively fixed by Parliament by law and, until provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. 98. Secretariat of Parliament. 1. Each House of Parliament shall have a separate secretarial staff. Provided that nothing in this clause shall be construed as preventing the creation of posts common to both Houses of Parliament. 2. Parliament may by law regulate the recruitment, and the conditions of service of persons appointed, to the secretarial staff of either House of Parliament. 3. Until provision is made by Parliament under Clause 2, the President may, after consultation with the Speaker of the House of the People or the Chairman of the Council of States, as the case may be, make rules regulating the recruitment, and the conditions of service of persons appointed, to the secretarial staff of the House of the People or the Council of States, and any rules so made shall have effect subject to the provisions of any law made under the said clause. 44. The Constitution of India, Part 5, the Union Conduct of Business, 99. Oath or affirmation by members. Every member of either House of Parliament shall, before taking his seat, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 100. Voting in Houses. Power of Houses to act notwithstanding vacancies and quorum. 1. Save as otherwise provided in this Constitution, all questions at any sitting of either House or joint sitting of the Houses shall be determined by a majority of votes of the members present and voting, other than the Speaker or person acting as Chairman or Speaker. The Chairman or Speaker, or person acting as such, shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. 2. Either House of Parliament shall have power to act notwithstanding any vacancy in the membership thereof, and any proceedings in Parliament shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or voted or otherwise took part in the proceedings. 1-3 Until Parliament by law otherwise provides, the quorum to constitute a meeting of either House of Parliament shall be 1/10 of the total number of members of the House. 4 If at any time during a meeting of a House there is no quorum, it shall be the duty of the Chairman or Speaker, or person acting as such, either to adjourn the House or to suspend the meeting until there is a quorum. Disqualifications of members 101. Vacation of seats. 1. No person shall be a member of both Houses of Parliament, and provision shall be made by Parliament by law for the vacation by a person who is chosen a member of both Houses of his seat in one House or the other. Blank, underscore, blank, 1. CLs. 3 and 4 omitted by the Constitution 42nd Amendment Act, 1976, S. 18 date not notified. This amendment was omitted by the Constitution 44th Amendment Act, 1978, S. 45 W. E. F. The 20th of June 1979. 45 The Constitution of India Part 5, the Union 2. No person shall be a member both of Parliament and of a House of the Legislature of a State 1 *****, and if a person is chosen a member both of Parliament and of a House of the Legislature of 2 expiration of such period as may be specified in rules a state then, at the made by the President, that person's seat in Parliament shall become vacant, unless he has previously resigned his seat in the legislature of the state. 3. If a member of either House of Parliament, it becomes subject to any of the disqualifications mentioned in 3 Clause 1 or Clause 2 of Article 102 or 4b resigns his seat by writing under his hand addressed to the Chairman or the Speaker, as the case may be, and his resignation is accepted by the Chairman or the Speaker, as the case may be, his seat shall thereupon become vacant. 5. Provided that in the case of any resignation referred to in subclause b, if from information received or otherwise and after making such inquiry as he thinks fit, the Chairman or the Speaker, as the case may be, is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. 4. If for a period of 60 days a member of either House of Parliament is without permission of the House absent from all meetings thereof, the House may declare his seat vacant, provided that in computing the said period of 60 days no account shall be taken of any period during which the House is prorogued or is adjourned for more than 4 consecutive days. ___1. The words and letters, specified in Part A or Part B of the first schedule, omitted by the Constitution 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956. 2. Subs. By S. 29 and SCH. Ibid. For such a state. W. E. F. The 11th of January 1956. See the Prohibition of Simultaneous Membership Rules, 1950, published with the Ministry of Law, Notifin. No. F. 4650th C. Dated the 26th of January 1950, Gazette of India, Extraordinary, p. 678. 3. Subs. By the Constitution 52nd Amendment Act, 1985, S. 2, for, cl. 1 of art. 102 inches W. E. F. The 3rd of January 1985. 4. Subs. By the Constitution 33rd Amendment Act, 1974, S. 2 W. E. F. The 19th of May 1974. 5. Ins. By S.2, Ibid. W. E. F. The 19th of May 1974. 46. The Constitution of India, Part 5, the Union 102. Disqualifications for membership. 1. A person shall be disqualified for being chosen as, and for being, a member of either House of Parliament. 1a. If he holds any office of profit under the Government of India or the Government of any state, other than an office declared by Parliament by law not to disqualify its holder. B. If he is of unsound mind and stands so declared by a competent court. C. If he is an undischarged insolvent. D. If he is not a citizen of India, or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state. E. If he is so disqualified by or under any law made by Parliament. 2. Explanation. For the purposes of this clause, a person shall not be deemed to hold an office of profit under the Government of India or the Government of any state by reason only that he is a minister either for the Union or for such state. 3. 2. A person shall be disqualified for being a member of either House of Parliament if he is so disqualified under the 10th Schedule. 4. 103. Decision on questions as to disqualifications of members. 1. If any question arises as to whether a member of either House of Parliament has become subject to any of the disqualifications mentioned in Clause 1 of Article 102, the question shall be referred for the decision of the President and his decision shall be final. ___1. Subs. By the Constitution 42nd Amendment Act, 1976, S. 19 to read as, a. If he holds any such office of profit under the Government of India or the Government of any state as is declared by Parliament by law to disqualify its holder, date not notified. This amendment was omitted by the Constitution 44th Amendment Act, 1978, S. 45 W. E. F. The 20th of June 1979. 2. Subs. By the Constitution 52nd Amendment Act, 1985, S. 3, for, 2, for the purposes of this art. W. E. F. The 3rd of January 1985. 3. Ins. By S. 3, Ibid. W. E. F. The 3rd of January 1985. 4. Subs. By the Constitution 42nd Amendment Act, 1976, S. 20, for Art. 103 W. E. F. The 1st of March 1977, and further subs. By the Constitution 44th Amendment Act, 1978, S. 14, for Art. 103 W. E. F. The 20th of June 1979. 47. The Constitution of India Part 5. The Union 2. Before giving any decision on any such question, the President shall obtain the opinion of the Election Commission and shall act according to such opinion. 104. Penalty for sitting and voting before making oath or affirmation under Article 99 or when not qualified or when disqualified. If a person sits or votes as a member of either House of Parliament before he has complied with the requirements of Article 99, or when he knows that he is not qualified or that he is disqualified for membership thereof, or that he is prohibited from so doing by the provisions of any law made by Parliament, he shall be liable in respect of each day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the Union. Powers, privileges and immunities of Parliament and its members. 105. Powers, privileges, etc., of the Houses of Parliament and of the members and committees thereof. 1. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. 2. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of either House of Parliament of any report, paper, votes or proceedings. 1-3. In other respects, the powers, privileges and immunities of each House of Parliament, and of the members and the committees of each House, shall be such as may from time to time be defined by Parliament by law, and, until so defined, 2. Shall be those of that House and of its members and committees immediately before the coming into force of Section 15 of the Constitution 44th Amendment Act, 1978. Blank, underscore, blank, 1. Subs. By the Constitution 42nd Amendment Act, 1976, S. 21. Date to be notified. This amendment was omitted by the Constitution 44th Amendment Act, 1978, S. 45 W. E. F. The 20th of June 1979. 2. Subs. By the Constitution 44th Amendment Act, 1978, S. 15, for certain words W. E. F. The 20th of June 1979. 48. The Constitution of India Part 5. The Union 4. The provisions of clauses 1, 2, and 3 shall apply in relation to persons who by virtue of this Constitution have the right to speak in, and otherwise to take part in the proceedings of, a House of Parliament or any committee thereof as they apply in relation to members of Parliament. 106. Salaries and allowances of members. Members of either House of Parliament shall be entitled to receive such salaries and allowances as may from time to time be determined by Parliament by law and, until provision in that respect is so made, allowances at such rates and upon such conditions as were immediately before the commencement of this Constitution applicable in the case of members of the Constituent Assembly of the Dominion of India. Legislative procedure. 107. Provisions as to introduction and passing of bills. 1. Subject to the provisions of Articles 109 and 117 with respect to money bills and other financial bills, a bill may originate in either House of Parliament. 2. Subject to the provisions of Articles 108 and 109, a bill shall not be deemed to have been passed by the Houses of Parliament unless it has been agreed to by both Houses, either without amendment or with such amendments only as are agreed to by both Houses. 3. A bill pending in Parliament shall not lapse by reason of the prorogation of the Houses. 4. A bill pending in the Council of States which has not been passed by the House of the People shall not lapse on a dissolution of the House of the People. 5. A bill which is pending in the House of the People, or which having been passed by the House of the People is pending in the Council of States, shall, subject to the provisions of Article 108, lapse on a dissolution of the House of the People. 108. Joint sitting of both Houses in certain cases. 1. If after a bill has been passed by one House and transmitted to the other House, A. The bill is rejected by the other House, or B. The Houses have finally disagreed as to the amendments to be made in the bill, or C. More than 6 months elapse from the date of the reception of the bill by the other House without the bill being passed by it. 49. The Constitution of India Part 5. The Union. The President may, unless the bill has elapsed by reason of a dissolution of the House of the People, notify to the Houses by message if they are sitting or by public notification if they are not sitting, his intention to summon them to meet in a joint sitting for the purpose of deliberating and voting on the bill, provided that nothing in this clause shall apply to a money bill. 2. In reckoning any such period of 6 months as is referred to in Clause 1, no account shall be taken of any period during which the House referred to in subclause C of that clause is prorogued or adjourned for more than 4 consecutive days. 3. Where the President has under Clause 1 notified his intention of summoning the Houses to meet in a joint sitting, neither House shall proceed further with the bill, but the President may at any time after the date of his notification summon the Houses to meet in a joint sitting for the purpose specified in the notification and, if he does so, the Houses shall meet accordingly. 4. If at the joint sitting of the two Houses the bill, with such amendments, if any, as are agreed to in joint sitting, is passed by a majority of the total number of members of both Houses present and voting, it shall be deemed for the purposes of this Constitution to have been passed by both Houses, provided that at a joint sitting, a. If the bill, having been passed by one House, has not been passed by the other House with amendments and returned to the House in which it originated, no amendment shall be proposed to the bill other than such amendments, if any, as are made necessary by the delay in the passage of the bill. B. If the bill has been so passed and returned, only such amendments as aforesaid shall be proposed to the bill and such other amendments as are relevant to the matters with respect to which the Houses have not agreed, and the decision of the person presiding as to the amendments which are admissible under this clause shall be final. 5. A joint sitting may be held under this article and a bill passed thereat, notwithstanding that a dissolution of the House of the People has intervened since the President notified his intention to summon the Houses to meet therein. 109. Special procedure in respect of money bills. 1. A money bill shall not be introduced in the Council of States. 50. The Constitution of India, Part 5, the Union. 2. After a money bill has been passed by the House of the People, it shall be transmitted to the Council of States for its recommendations, and the Council of States shall within a period of 14 days from the date of its receipt of the bill return the bill to the House of the People with its recommendations, and the House of the People may thereupon either accept or reject all or any of the recommendations of the Council of States. 3. If the House of the People accepts any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both Houses with the amendments recommended by the Council of States and accepted by the House of the People. 4. If the House of the People does not accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both Houses in the form in which it was passed by the House of the People without any of the amendments recommended by the Council of States. 5. If a money bill passed by the House of the People and transmitted to the Council of States for its recommendations is not returned to the House of the People within the said period of 14 days, it shall be deemed to have been passed by both Houses at the expiration of the said period in the form in which it was passed by the House of the People. 110. Definition of money bills. 1. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely, a. The imposition, abolition, remission, alteration or regulation of any tax. B. The regulation of the borrowing of money or the giving of any guarantee by the Government of India, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the Government of India. C. The custody of the Consolidated Fund or the Contingency Fund of India, the payment of monies into or the withdrawal of monies from any such fund. D. The appropriation of monies out of the Consolidated Fund of India. E. The declaring of any expenditure to be expenditure charged on the Consolidated Fund of India or the increasing of the amount of any such expenditure. 51. The Constitution of India, Part 5, the Union. F. The receipt of money on account of the Consolidated Fund of India or the public account of India or the custody or issue of such money or the audit of the accounts of the Union or of a state. Or G. Any matter incidental to any of the matters specified in subclauses A to F. 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. 4. There shall be endorsed on every money bill when it is transmitted to the Council of States under Article 109, and when it is presented to the President for assent under Article 111, the certificate of the Speaker of the House of the People signed by him that it is a money bill. 111. Assent to bills. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill, or that he withholds assent therefrom. provided that the President may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof and, in particular, will consider the desirability of introducing any such amendments as he may recommend in his message, and when a bill is so returned, the Houses shall reconsider the bill accordingly, and if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Procedure in Financial Matters 112. Annual Financial Statement. 1. The President shall in respect of every financial year cause to be laid before both the Houses of Parliament a statement of the estimated receipts and expenditure of the Government of India for that year, in this part referred to as the Annual Financial Statement. 2. The estimates of expenditure embodied in the Annual Financial Statement shall show separately. 52. The Constitution of India Part 5. The Union 8. The sums required to meet expenditure described by this Constitution as expenditure charged upon the Consolidated Fund of India, and b. The sums required to meet other expenditure proposed to be made from the Consolidated Fund of India, and shall distinguish expenditure on revenue account from other expenditure. 3. The following expenditure shall be expenditure charged on the Consolidated Fund of India: a. The emoluments and allowances of the President and other expenditure relating to his office. B. The salaries and allowances of the Chairman and the Deputy Chairman of the Council of States and the Speaker and the Deputy Speaker of the House of the People. C. Debt charges for which the Government of India is liable including interest, sinking fund charges and redemption charges, and other expenditure relating to the raising of loans and the service and redemption of debt. D. I. The salaries, allowances and pensions payable to or in respect of judges of the Supreme Court. E. The pensions payable to or in respect of judges of the Federal Court. E. The pensions payable to or in respect of judges of any high court which exercises jurisdiction in relation to any area included in the territory of India or which at any time before the commencement of this Constitution exercised jurisdiction in relation to any area included in 1. A governor's province of the Dominion of India. E. The salary, allowances and pension payable to or in respect of the Controller and Auditor General of India. F. Any sums required to satisfy any judgment, decree or award of any court or arbitral tribunal. G. Any other expenditure declared by this Constitution or by Parliament by law to be so charged. 113. Procedure in Parliament with respect to estimates. 1. So much of the estimates as relates to expenditure charged upon the Consolidated Fund of India shall not be submitted to the vote of Parliament, but nothing in this clause shall be construed as preventing the discussion in either House of Parliament of any of those estimates. Blank, underscore, blank, 1. Subs. By the Constitution, 7th Amendment Act, 1956, s. 29 and sch. For, a province corresponding to a state specified in Part A of the First Schedule, W. E. F. The 11th of January 1956. 53. The Constitution of India Part 5. The Union 2. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for grants to the House of the People, and the House of the People shall have power to assent, or to refuse to assent, to any demand, or to assent to any demand subject to a reduction of the amount specified therein. 3. No demand for a grant shall be made except on the recommendation of the President. 114. Appropriation Bills. 1. As soon as may be after the grants under Article 113 have been made by the House of the People, there shall be introduced a bill to provide for the appropriation out of the Consolidated Fund of India of all monies required to meet a. The grants so made by the House of the People, and b. The expenditure charged on the Consolidated Fund of India but not exceeding in any case the amount shown in the statement previously laid before Parliament. 2. No amendment shall be proposed to any such bill in either House of Parliament which will have the effect of varying the amount or altering the destination of any grant so made or of varying the amount of any expenditure charged on the Consolidated Fund of India, and the decision of the person presiding as to whether an amendment is inadmissible under this clause shall be final. 3. Subject to the provisions of Articles 115 and 116, no money shall be withdrawn from the Consolidated Fund of India except under appropriation made by law passed in accordance with the provisions of this article. 115. Supplementary, additional or excess grants. 1. The President shall, a. If the amount authorized by any law made in accordance with the provisions of Article 114 to be expended for a particular service for the current financial year is found to be insufficient for the purposes of that year or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or b. If any money has been spent on any service during a financial year in excess of the amount granted for that service and for that year, cause to be laid before both the Houses of Parliament. Another statement showing the estimated amount of that expenditure or cause to be presented to the House of the People. A demand for such excess, as the case may be. 54. The Constitution of India, Part 5, the Union 2. The provisions of Articles 112, 113 and 114 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the Consolidated Fund of India to meet such expenditure or the grant in respect of such demand as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant and the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure or grant. 116. Votes on account, votes of credit and exceptional grants. 1. Notwithstanding anything in the foregoing provisions of this chapter, the House of the People shall have power, a. to make any grant in advance in respect of the estimated expenditure for a part of any financial year pending the completion of the procedure prescribed in Article 113 for the voting of such grant and the passing of the law in accordance with the provisions of Article 114 in relation to that expenditure. B. To make a grant for meeting an unexpected demand upon the resources of India when on account of the magnitude or the indefinite character of the service the demand cannot be stated with the details ordinarily given in an annual financial statement. C. To make an exceptional grant which forms no part of the current service of any financial year, and Parliament shall have power to authorize by law the withdrawal of monies from the Consolidated Fund of India for the purposes for which the said grants are made. 2. The provisions of Articles 113 and 114 shall have effect in relation to the making of any grant under Clause 1, and to any law to be made under that clause as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement, and the law to be made for the authorization of appropriation of monies out of the Consolidated Fund of India to meet such expenditure. 117. Special provisions as to financial bills. 1. A bill or amendment making provision for any of the matters specified in sub-clauses A to F of Clause 1 of Article 110 shall not be introduced or moved except on the recommendation of the President, and a bill making such provision shall not be introduced in the Council of States, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. 55. The Constitution of India, Part 5, the Union 2. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. 3. A bill which, if enacted and brought into operation, would involve expenditure from the Consolidated Fund of India shall not be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. Procedure generally. 118. Rules of Procedure. 1. Each House of Parliament may make rules for regulating, subject to the provisions of this Constitution, its procedure and the conduct of its business. 2. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this Constitution with respect to the legislature of the Dominion of India shall have effect in relation to Parliament, subject to such modifications and adaptations as may be made therein by the Chairman of the Council of States or the Speaker of the House of the People, as the case may be. 3. The President, after consultation with the Chairman of the Council of States and the Speaker of the House of the People, may make rules as to the procedure with respect to joint sittings of, and communications between, the two Houses. 4. At a joint sitting of the two Houses the Speaker of the House of the People, or in his absence such person as may be determined by rules of procedure made under Clause 3, shall preside. 119. Regulation by law of procedure in Parliament in relation to financial business. Parliament may, for the purpose of the timely completion of financial business, regulate by law the procedure of, and the conduct of business in each House of Parliament in relation to any financial matter or to any bill for the appropriation of monies out of the Consolidated Fund of India, and, if in so far as any provision of any law so made is inconsistent with any rule made by a House of Parliament under Clause 1 of Article 118 or with any rule or standing order having effect in relation to Parliament under Clause 2 of that article, such provision shall prevail. Blank, underscore, blank, the brackets and words, including the quorum to constitute a meeting of the House, ins. By the Constitution 42nd Amendment Act, 1976, s. 22, date not notified. This amendment was omitted by the Constitution 44th Amendment Act, 1978, s. 45 w. e. f. The 20th of June 1979. 56. The Constitution of India, Part 5, the Union 120. Language to be used in Parliament. 1. Notwithstanding anything in Part 17, but subject to the provisions of Article 348, business in Parliament shall be transacted in Hindi or in English, provided that the Chairman of the Council of States or Speaker of the House of the People, or person acting as such, as the case may be, may permit any member who cannot adequately express himself in Hindi or in English to address the House in his mother tongue. 2. Unless Parliament by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effect as if the words, or in English, were omitted therefrom. 121. Restriction on discussion in Parliament. No discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties except upon a motion for presenting an address to the President praying for the removal of the judges hereinafter provided. 122. Courts not to inquire into proceedings of Parliament. 1. The validity of any proceedings in Parliament shall not be called in question on the ground of any alleged irregularity of procedure. 2. No officer or member of Parliament in whom powers are vested by or under this Constitution for regulating procedure or the conduct of business, or for maintaining order, in Parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. Chapter 3. Legislative page nari of the page resident. 123. Power of President to promulgate ordinances during recess of Parliament. 1. If at any time, except when both Houses of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear to him to require. 2. An ordinance promulgated under this article shall have the same force and effect as an Act of Parliament, but every such ordinance, a. shall be laid before both Houses of Parliament and shall cease to operate at the expiration of 6 weeks from the reassembly of Parliament, or, if before the expiration of that period resolutions disapproving it are passed by both Houses, upon the passing of the second of those resolutions, and 57. The Constitution of India, Part 5, the Union B may be withdrawn at any time by the President. Explanation. Where the Houses of Parliament are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those dates for the purposes of this clause. 3. If and so far as an ordinance under this article makes any provision which Parliament would not under this Constitution be competent to enact, it shall be void. 1. 4. See Chapter *IV. Thu Nyan J. Judiciary * 124. Establishment and Constitution of the Supreme Court. 1. There shall be a Supreme Court of India consisting of a Chief Justice of India and, until Parliament by law prescribes a larger number, of not more than 7 other judges. 2. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal. 2. On the recommendation of the National Judicial Appointments Commission referred to in Article 124A and shall hold office until he attains the age of 65 years. 3. 4. Provided that a judge may, by writing under his hand addressed to the President, resign his office, b. a judge may be removed from his office in the manner provided in Clause 4. ___1. Ins. By the Constitution 38th Amendment Act, 1975, s. 2 with retrospective effect, and omitted by the Constitution 44th Amendment Act, 1978, s. 16 w. e. f. The 20th of June 1979. Now, 33. V. The Supreme Court Number of Judges Amendment Act, 2019 37 of 2019 S. 2 W. E. F. The 8th of September 2019. 2. Subs. By the Constitution 99th Amendment Act, 2014, S. 2. For, after consultation with such of the judges of the Supreme Court and of the High Court in the states as the President may deem necessary for the purpose, W. E. F. The 13th of April 2015. This amendment has been struck down by the Supreme Court in the case of Supreme Court Advocates on Record Association and in other verses. Union of India in its judgment dated 16 October 2015, Air 2016 SC 117. 3. The first proviso was omitted by S. 2. Ibid. The proviso was as under. Provided that in the case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall always be consulted. This amendment has been struck down by the Supreme Court in the case of Supreme Court Advocates on Record Association and in other verses. Union of India in its judgment dated 16 October 2015, Air 2016 SC 117. 4. subs. By S. 2, ibid. For, provided further that, this amendment has been struck down by the Supreme Court in the Supreme Court Advocates on Record Association and Another vs. Union of India judgment dated 16 October 2015, Air 2016 SC 117. 58. The Constitution of India Part 5, the Union 1-2a, the age of a judge of the Supreme Court shall be determined by such authority and in such manner as Parliament may by law provide. 3. A person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and a. has been for at least 5 years a judge of a high court or of 2 or more such courts in succession, or b. has been for at least 10 years an advocate of a high court or of 2 or more such courts in succession, or c. is, in the opinion of the President, a distinguished jurist. Explanation I. In this clause, High Court means a high court which exercises, or which at any time before the commencement of this Constitution exercised, jurisdiction in any part of the territory of India. Explanation 2. In computing for the purpose of this clause the period during which a person has been an advocate, any period during which a person has held judicial office not inferior to that of a district judge after he became an advocate shall be included. 4. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of Parliament supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of that House present and voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. 5. Parliament may by law regulate the procedure for the presentation of an address and for the investigation and proof of the misbehavior or incapacity of a judge under Clause 4. 6. Every person appointed to be a judge of the Supreme Court shall, before he enters upon his office, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 7. No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. 2. 124a. National Judicial Appointments Commission. 1. There shall be a commission to be known as the National Judicial Appointments Commission consisting of the following, namely, blank, underscore, blank, 1. Ins. By the Constitution 15th Amendment Act, 1963, S. 2. W. E. F. The 10th of May 1963. 2. Ins. By the Constitution 99th Amendment Act, 2014, S. 3. W. E. F. The 13th of April 2015. This amendment has been struck down by the Supreme Court in the case of Supreme Court Advocates and Record Association and Another vs. Union of India in its judgment dated 16 October 2015, Air 2016 SC 117. 59. The Constitution of India Part 5, the Union 8. The Chief Justice of India, Chairperson, ex officio, the 2 other senior judges of the Supreme Court next to the Chief Justice of India, members, ex officio, c. The Union Minister in charge of law and justice, member, ex officio, d. 2 eminent persons to be nominated by the committee consisting of the Prime Minister, the Chief Justice of India and the Leader of Opposition in the House of the People, or where there is no such Leader of Opposition, then, the Leader of single largest opposition party in the House of the People, members, provided that one of the eminent persons shall be nominated from amongst the persons belonging to the scheduled castes, the scheduled tribes, other backward classes, minorities or women, provided further that an eminent person shall be nominated for a period of 3 years and shall not be eligible for renomination. 2. No act or proceedings of the National Judicial Appointments Commission shall be questioned or be invalidated merely on the ground of the existence of any vacancy or defect in the constitution of the Commission. 124b. Functions of Commission. It shall be the duty of the National Judicial Appointments Commission to a. Recommend persons for appointment as Chief Justice of India, Judges of the Supreme Court, Chief Justices of High Courts and other Judges of High Courts. b. Recommend transfer of Chief Justices and other Judges of High Courts from one High Court to any other High Court, and c. Ensure that the person recommended is of ability and integrity. 124c. Power of Parliament to make law. Parliament may, by law, regulate the procedure for the appointment of Chief Justice of India and other Judges of the Supreme Court and Chief Justices and other Judges of High Courts, and empower the Commission to lay down by regulations the procedure for the discharge of its functions, the manner of selection of persons for appointment and such other matters as may be considered necessary by it. 125. Salaries, etc., of judges. 1. There shall be paid to the judges of the Supreme Court such salaries as may be determined by Parliament by law and until provision in that behalf is so made, such salaries as are specified in the second schedule. 2. Every judge shall be entitled to such privileges and allowances and to such rights in respect of leave of absence and pension as may from time to time be determined by or under law made by Parliament and, until so determined, to such privileges, allowances and rights as are specified in the second schedule, ___1. Subs. By the Constitution 54th Amendment Act, 1986, S. 2, for CL. 1 W. E. F. 4 January 1986. 60. The Constitution of India, Part 5, the Union provided that neither the privileges nor the allowances of a judge nor his rights in respect of leave of absence or pension shall be varied to his disadvantage after his appointment. 126. Appointment of Acting Chief Justice. When the office of Chief Justice of India is vacant or when the Chief Justice is, by reason of absence or otherwise, unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. 127. Appointment of ad hoc judges. 1. If at any time there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, 1. The National Judicial Appointments Commission on a reference made to it by the Chief Justice of India, may with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned, request in writing the attendance at the sittings of the court, as an ad hoc judge, for such period as may be necessary, of a judge of a high court duly qualified for appointment as a judge of the Supreme Court to be designated by the Chief Justice of India. 2. It shall be the duty of the judge who has been so designated, in priority to other duties of his office, to attend the sittings of the Supreme Court at the time and for the period for which his attendance is required, and while so attending he shall have all the jurisdiction, powers and privileges, and shall discharge the duties, of a judge of the Supreme Court. 128. Attendance of retired judges at sittings of the Supreme Court. Notwithstanding anything in this chapter, 2. The National Judicial Appointments Commission may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or of the Federal Court 3. Or who has held the office of a judge of a high court and is duly qualified for appointment as a judge of the Supreme Court to sit and act as a judge of the Supreme Court, and every such person so requested shall, while so sitting and acting, be entitled to such allowances as the President may by order determine and have all the jurisdiction, powers and privileges of, but shall not otherwise be deemed to be, a judge of that court, ___1. Subs. By the Constitution 99th Amendment Act, 2014, S. 4, for, the Chief Justice of India may, with the previous consent of the President, W. E. F. 13th April 2015. This amendment has been struck down by the Supreme Court in the case of Supreme Court Advocates on Record Association and another versus. Union of India in its judgment dated 16 October 2015, Air 2016 SC 117. 2. Subs. By S. 5, Ibid. For, the Chief Justice of India, W. E. F. 13th April 2015. This amendment has been struck down by the Supreme Court in the case of Supreme Court Advocates and Record Association and another versus. Union of India in its judgment dated 16-102015, Air 2016 SC 117. 3. Ins. By the Constitution 15th Amendment Act, 1963, S. 3 W. E. F. 10 May 1963. 61. The Constitution of India, Part 5. The Union provided that nothing in this article shall be deemed to require any such person as aforesaid to sit and act as a judge of that court unless he consents so to do. 129. Supreme Court to be a court of record. The Supreme Court shall be a court of record and shall have all the powers of such a court including the power to punish for contempt of itself. 130. Seat of Supreme Court. The Supreme Court shall sit in Delhi or in such other place or places, as the Chief Justice of India may, with the approval of the President, from time to time, appoint. 131. Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute, a. between the Government of India and one or more states, or b. between the Government of India and any state or states on one side and one or more other states on the other, or c. between two or more states, if and in so far as the dispute involves any question whether of law or fact on which the existence or extent of a legal right depends, 1. Provided that the said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, sonat or other similar instrument which, having been entered into or executed before the commencement of this Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. 2. 131a. Exclusive jurisdiction of the Supreme Court in regard to questions as to constitutional validity of central laws. Omitted by the Constitution 43rd Amendment Act, 1977, S. 4 W. E. F. 13 April 1978. 132. Appellate jurisdiction of the Supreme Court in appeals from high courts in certain cases. 1. An appeal shall lie to the Supreme Court from any judgment, decree or final order of a high court in the territory of India, whether in a civil, criminal or other proceeding. 3. If the High Court certifies under Article 134a that the case involves a substantial question of law as to the interpretation of this Constitution. Blank, underscore, blank, 1. Subs. By the Constitution 7th Amendment Act, 1956, S. 5, for the proviso W. E. F. The 11th of January 1956. 2. Ins. By the Constitution 42nd Amendment Act, 1976, S. 23 W. E. F. The 2nd of January 1977. 3. Subs. By the Constitution 44th Amendment Act, 1978, S. 17, for, if the High Court certifies, W. E. F. The 8th of January 1979. 62. The Constitution of India Part 5, the Union 1, 2, 3 where such a certificate is given, 2 any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided to. Explanation. For the purposes of this article, the expression, final order, includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. 133. Appellate jurisdiction of the Supreme Court in appeals from high courts in regard to civil matters. 3. 1. An appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceeding of a high court in the territory of India. Article 134a. 4. If the High Court certifies under A that the case involves a substantial question of law of general importance, and B. that in the opinion of the High Court the said question needs to be decided by the Supreme Court. 2. Notwithstanding anything in Article 132, any party appealing to the Supreme Court under Clause 1 may urge as one of the grounds in such appeal that a substantial question of law as to the interpretation of this Constitution has been wrongly decided. 3. Notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree or final order of one judge of a high court. 134. Appellate jurisdiction of the Supreme Court in regard to criminal matters. 1. An appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a high court in the territory of India if the High Court A. has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or B. has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death, or C. certifies under Article 134a that the case is a fit one for appeal to the Supreme Court, blank, underscore, blank, 1. Cl. 2. Omitted by the Constitution 44th Amendment Act, 1978, S. 17, for, if the High Court certifies, W. E. F. The 8th of January 1979. 2. Certain words omitted by S. 17, ibid. W. E. F. The 8th of January 1979. 3. Subs. By the Constitution 30th Amendment Act, 1972, S. 2, for Cl. 1 W. E. F. The 27th of February 1973 4. Subs. By the Constitution 44th Amendment Act, 1978, S.18, for, if the High Court certifies, W. E. F. The 8th of January 1979. 5. Subs. By S. 19, ibid. For, certifies, W. E. F. The 8th of January 1979. 63. The Constitution of India Part 5, the Union provided that an appeal under subclause C shall lie subject to such provisions as may be made in that behalf under Clause 1 of Article 145 and to such conditions as the High Court may establish or require. 2. Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceeding of a High Court in the territory of India subject to such conditions and limitations as may be specified in such law. 134A. Certificate for appeal to the Supreme Court. Every High Court, passing or making a judgment, decree, final order, or sentence, referred to in Clause 1 of Article 132 or Clause 1 of Article 133, or Clause 1 of Article 134, A. May, if it deems fit so to do, on its own motion, and B. Shall, if an oral application is made, by or on behalf of the party aggrieved, immediately after the passing or making of such judgment. Decree, final order or sentence, determine, as soon as may be after such passing or making, the question whether a certificate of the nature referred to in Clause 1 of Article 132, or Clause 1 of Article 133 or, as the case may be, subclause C of Clause 1 of Article 134, may be given in respect of that case. 135. Jurisdiction and powers of the Federal Court under existing law to be exercisable by the Supreme Court. Until Parliament by law otherwise provides, the Supreme Court shall also have jurisdiction and powers with respect to any matter to which the provisions of Article 133 or Article 134 do not apply if jurisdiction and powers in relation to that matter were exercisable by the Federal Court immediately before the commencement of this Constitution under any existing law. 136. Special leave to appeal by the Supreme Court. 1. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. 2. Nothing in Clause 1 shall apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. 137. Review of judgments or orders by the Supreme Court. Subject to the provisions of any law made by Parliament or any rules made under Article 145, the Supreme Court shall have power to review any judgment pronounced or order made by it. Blank, underscore, blank, 1. Ins. By the Constitution 44th Amendment Act, 1978, S. 20 W. E. F. The 8th of January 1979. 64 The Constitution of India Part 5, The Union 138. Enlargement of the jurisdiction of the Supreme Court. 1. The Supreme Court shall have such further jurisdiction and powers with respect to any of the matters in the Union list as Parliament may by law confer. 2. The Supreme Court shall have such further jurisdiction and powers with respect to any matter as the Government of India and the Government of any state may by special agreement confer, if Parliament by law provides for the exercise of such jurisdiction and powers by the Supreme Court. 139. Conferment on the Supreme Court of powers to issue certain writs. Parliament may by law confer on the Supreme Court power to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them, for any purposes other than those mentioned in Clause 2 of Article 32. 139A. Transfer of certain cases. 2. 1. Where cases involving the same or substantially the same questions of law are pending before the Supreme Court and one or more High Courts or before two or more High Courts and the Supreme Court is satisfied on its own motion or on an application made by the Attorney General of India or by a party to any such case that such questions are substantial questions of general importance, the Supreme Court may withdraw the case or cases pending before the High Court or the High Courts and dispose of all the cases itself, provided that the Supreme Court may after determining the said questions of law return any case so withdrawn together with a copy of its judgment on such questions to the High Court from which the case has been withdrawn, and the High Court shall on receipt thereof, proceed to dispose of the case in conformity with such judgment. 2. The Supreme Court may, if it deems it expedient so to do for the ends of justice, transfer any case, appeal or other proceedings pending before any High Court to any other High Court. 140. Ancillary powers of the Supreme Court. Parliament may by law make provision for conferring upon the Supreme Court such supplemental powers not inconsistent with any of the provisions of this Constitution as may appear to be necessary or desirable for the purpose of enabling the Court more effectively to exercise the jurisdiction conferred upon it by or under this Constitution. Blank, underscore, blank, 1. Ins. By the Constitution 42nd Amendment Act, 1976, S. 24 W. E. F. The 2nd of January 1977. 2. Subs. By the Constitution 44th Amendment Act, 1978, S. 21, for CL. 1 W. E. F. The 8th of January 1979. 65 The Constitution of India Part 5, the Union 141. Law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. 142. Enforcement of decrees and orders of the Supreme Court and orders as to discovery, etc. 1. The Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament and, until provision in that behalf is so made, in such manner as the President may by order 1 prescribe. 2. Subject to the provisions of any law made in this behalf by Parliament, the Supreme Court shall, as respects the whole of the territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any documents, or the investigation or punishment of any contempt of itself. 143. Power of the President to consult the Supreme Court. 1. If at any time it appears to the President that a question of law or fact has arisen, or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. 2. The President may, notwithstanding anything in 2 Article 131, refer a dispute of the kind mentioned in the 3 the proviso to said proviso to the Supreme Court for opinion, and the Supreme Court shall, after such hearing as it thinks fit, report to the President its opinion thereon. 144. Civil and judicial authorities to act in aid of the Supreme Court. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. 4. 144a. Special provisions as to disposal of questions relating to constitutional validity of laws, omitted by the Constitution 43rd Amendment Act, 1977, S. 5 W. E. F. 13 April 1978. 145. Rules of Court, etc. 1. Subject to the provisions of any law made by Parliament, the Supreme Court may from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including 8. Rules as to the persons practicing before the court, ___, 1. See the Supreme Court Decrees and Orders Enforcement Order, 1954, CO. 47. 2. The words, brackets and figure, Clause I of, omitted by the Constitution 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956. 3. Subs. By S. 29 and SCH. Ibid. For, said clause, W. E. F. The 11th of January 1956. 4. Ins. By the Constitution 42nd Amendment Act, 1976, S. 25 W. E. F. The 2nd of January 1977. 66 The Constitution of India Part 5, the Union B. Rules as to the procedure for hearing appeals and other matters pertaining to appeals, including the time within which appeals to the court are to be entered. C. Rules as to the proceedings in the court for the enforcement of any of the rights conferred by Part 3. 1. CC. Rules as to the proceedings in the court under 139A. 2. Article D. Rules as to the entertainment of appeals under Subclause C of Clause 1 of Article 134. E. Rules as to the conditions subject to which any judgment pronounced or order made by the court may be reviewed and the procedure for such review, including the time within which applications to the court for such review are to be entered. F. Rules as to the costs of an incidental to any proceedings in the court and as to the fees to be charged in respect of proceedings therein. G. Rules as to the granting of bail. H. Rules as to stay of proceedings. I. Rules providing for the summary determination of any appeal which appears to the court to be frivolous or vexatious or brought for the purpose of delay. J. Rules as to the procedure for inquiries referred to in Clause 1 of Article 317. 2. Subject to the 3 provisions of 4 Clause 3. Rules made under this article may fix the minimum number of judges who are to sit for any purpose. 5. 4. And may provide for the powers of single judges and division courts. 3. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this Constitution or for the purpose of hearing any reference under Article 143 shall be 5, __, 1. Ins. By the Constitution 42nd Amendment Act, 1976, S. 26 W. E. F. the 2nd of January 1977. 2. Subs. By the Constitution 43rd Amendment Act, 1977, s. 6, for Articles 131A and 139A, W, E, F. The 13th of April 1978. 3. Subs. By the Constitution 42nd Amendment Act, 1976, s. 26, for provisions of Clause 3 W, E, F. The 2nd of January 1977. 4. Certain words omitted by the Constitution 43rd Amendment Act, 1977, s. 6 W, E, F. The 13th of April 1978. 5. Subs. By the Constitution 42nd Amendment Act, 1976, s. 26, for the minimum number, W, E, F. The 2nd of January 1977. 67. The Constitution of India Part 5, the Union provided that, where the court hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges and in the course of the hearing of the appeal the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such a question and shall on receipt of the opinion dispose of the appeal in conformity with such opinion. 4. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with an opinion also delivered in open court. 5. No judgment and no such opinion shall be delivered by the Supreme Court save with the concurrence of a majority of the judges present at the hearing of the case, but nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. 146. Officers and servants and the expenses of the Supreme Court. 1. Appointments of officers and servants of the Supreme Court shall be made by the Chief Justice of India or such other judge or officer of the court as he may direct, provided that the President may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, save after consultation with the Union Public Service Commission. 2. Subject to the provisions of any law made by Parliament, the conditions of service of officers and servants of the Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for the purpose, provided that the rules made under this clause shall, so far as they relate to salaries, allowances, leave or pensions, require the approval of the President. 3. The administrative expenses of the Supreme Court, including all salaries, allowances and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the Consolidated Fund of India, and any fees or other monies taken by the court shall form part of that fund. 68. The Constitution of India Part 5, the Union 147. Interpretation. In this chapter and in Chapter 5 of Part 6, references to any substantial question of law as to the interpretation of this Constitution shall be construed as including references to any substantial question of law as to the interpretation of the Government of India Act, 1935, including any enactment amending or supplementing that Act, or of any order in council or order made thereunder, or of the Indian Independence Act, 1947, or of any order made thereunder. CHAPTERV. COMPTROLLER and AUDITORGENERAL of INDIA 148. Controller and Auditor General of India. 1. There shall be a Controller and Auditor General of India who shall be appointed by the President by warrant under his hand and seal and shall only be removed from office in like manner and on the like grounds as a judge of the Supreme Court. 2. Every person appointed to be the Controller and Auditor General of India shall, before he enters upon his office, make and subscribe before the President, or some person appointed in that behalf by him, an oath or affirmation according to the form set out for the purpose in the third schedule. 3. The salary and other conditions of service of the Controller and Auditor General shall be such as may be determined by Parliament by law and, until they are so determined, shall be as specified in the second schedule, provided that neither the salary of a Controller and Auditor General nor his rights in respect of leave of absence, pension or age of retirement shall be varied to his disadvantage after his appointment. 4. The Controller and Auditor General shall not be eligible for further office either under the Government of India or under the government of any state after he has ceased to hold his office. 5. Subject to the provisions of this Constitution and of any law made by Parliament, The conditions of service of persons serving in the Indian Audit and Accounts Department and the administrative powers of the Controller and Auditor General shall be such as may be prescribed by rules made by the President after consultation with the Controller and Auditor General. 6. The administrative expenses of the Office of the Controller and Auditor General, including all salaries, allowances and pensions payable to or in respect of persons serving in that office, shall be charged upon the Consolidated Fund of India. 69. The Constitution of India, Part 5, the Union 149. Duties and powers of the Controller and Auditor General. The Controller and Auditor General shall perform such duties and exercise such powers in relation to the accounts of the Union and of the States and of any other authority or body as may be prescribed by or under any law made by Parliament and, until provision in that behalf is so made, shall perform such duties and exercise such powers in relation to the accounts of the Union and of the States as were conferred on or exercisable by the Auditor General of India immediately before the commencement of this Constitution in relation to the accounts of the Dominion of India and of the provinces respectively. 1-150. Form of accounts of the Union and of the States. The accounts of the Union and of the States shall be kept in such form as the President may, on the advice of the Controller and Auditor General of India, prescribe. 151. Audit Reports. 1. The reports of the Controller and Auditor General of India relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each House of Parliament. 2. The reports of the Controller and Auditor General of India relating to the accounts of a state shall be submitted to the Governor 3*** of the state, who shall cause them to be laid before the legislature of the state. Blank, underscore, blank, 1. Subs. By the Constitution 42nd Amendment Act, 1976, S. 27, for Art.150 W. E. F. The 4th of January 1977. 2. Subs. By the Constitution 44th Amendment Act, 1978, S. 22, for, after consultation with, W. E. F. The 20th of June 1979. 3. The words, Rajpramukh, omitted by the Constitution 7th Amendment Act, 1956, S. 29 and SCH. W. E. F. The 11th of January 1956.